Perfect.
Okay, great. Yes, amazing. Okay. So before we get started, I need to go over a few important reminders. First, this presentation is being live streamed. Questions will be taken at the end if time permits and answered live. If you're watching at a library, you may walk up to the computer to ask or submit your questions to the library staff. If you're watching via Zoom, please use the Q&A section. And if you're watching via Facebook, please submit questions in the comment section. Please remember that all comments are public and visible during and after the presentation. Finally, please keep your questions general and not case specific. The attorney can provide information about the law and legal processes, but cannot give advice on individual cases. Next slide, please. Please note that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on information provided in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. If you need assistance finding legal help in Louisiana, please go to the Louisiana Civil Legal Navigator. The link is listed in the information. The LSBA's inclusion of a program is not to be deemed a statement or an endorsement of the views expressed therein by the LSBA or any member of the LSBA. Speakers on LSBA programs were carefully selected for their knowledge, but neither the LSBA nor the speaker warrant that the presentations or materials were free of errors or will continue to be accurate. Statements in the presentations and their materials should be verified before relying on them. Opinions expressed are those of the speakers and do not necessarily reflect the opinions of the LSBA, its sections, or committees. Views expressed are those of the authors and contributors only. So as I mentioned before, our presenter today is Alex Nichols. She works at the Louisiana Fair Housing Action Center, and she's got a ton of experience working with housing and landlord tenant issues. So without further ado, Alex.
Okay. Hi, everyone. Thank you so much for attending this chat or workshop. My name is Alex Nichols, and I'm going to tell you guys a little bit more about the Louisiana Fair Housing Action Center, and then we'll dive into some other general information. So the Louisiana Fair Housing Action Center, or LaFAC, as I'll be calling it, is a nonprofit civil rights organization established in 1995 to eradicate housing discrimination. What do we do? So we do a bunch of different things. The area that I'm most knowledgeable about is enforcement. We investigate discrimination throughout Louisiana. We represent individuals who've experienced housing discrimination, and we provide eviction defense services. And those are all areas we'll be talking about more throughout this talk. We also do some policy work. So we work to pass laws that protect individuals and advocate for housing accessibility at the state, city, and federal level. We also do a homeownership counseling. We assist homeowners with a variety of post-purchase issues, including foreclosure prevention, as well as education. And we train first-time homebuyers, tenants, landlords, realtors, and more on fair housing rights and their responsibilities to protect them. A little bit more about me. My name is Alex Nichols. I started at LaFac in 2024. I initially was doing eviction defense in Orleans Parish, but I've now switched to do investigating housing discrimination and representing individuals who experience it. So hopefully I'm pretty knowledgeable about this area. Our talk today is going to be on the Fair Housing Act and its protections. And we're also going to discuss some landlord tenant issues, and we'll touch on eviction defense at the end. I wanted to discuss, we'll also have time for questions at the end. So feel free to throw them into the chat. I'm excited to answer some of them. Throughout, I'll be mentioning resources and other organizations who you can reach out to if you're having any housing issues. And I also want to give a quick shout out that April is Fair Housing Month. So thank you so much for attending this during this very important time of year. So the National Fair Housing Alliance estimates that there are more than 4 million acts of housing discrimination occurring each year, but unfortunately only a fraction are reported. This is a major issue that families and individuals are facing throughout the country, but it's rarely addressed. Housing discrimination occurs when an individual or an institution takes away your ability to choose housing based on your needs or preferences. It doesn't just take away a particular house or an apartment from your consideration. It takes away everything that you would have been able to access living in that place. So that can be living closer to your work, accessing better schools, having closer accessibility to supermarkets or restaurants. It's so much more than just not being able to live in that particular apartment or house. So my goal for today is to make sure that you can advocate for yourself. If you're facing discrimination, I want you to know, I want you to be able to do something about it. If you're having issues with your landlord, I want to make sure that you can protect yourself and your rights, and especially when it comes to eviction defense. This is an area of law that not many lawyers know a lot about, and so I want to make sure that you are doing everything you can to protect yourself. So the Fair Housing Act, it was passed in on April 11th, 1968. It was passed 7 days after Martin Luther King's assassination, and he was a very large proponent for I guess against housing discrimination. The subsequent rioting that after his assassination is what pushed Congress to do this last Civil Rights Act. Been a lot of resistance to it since discrimination was so prevalent in the housing communities. And so, unfortunately, it was really due to his assassination that we have these protections today. The Fair Housing Act made it illegal to deny someone housing based on their membership in a protected class, and there are now 7 classes that are protected under this act. The first is race, and that's the one that most people associate with the Fair Housing Act. It also protects people from color discrimination or based on their skin color, as well as national origin. And that's not just for immigrants who've moved to this country, but also how people perceive you, where your people are from. There's also another protected class is sex, and that doesn't just mean your biological sex, it can also mean gender identity and sexual orientation. Although right now that's a bit contentious, but nonetheless, that's how HUD has advised us to react to sex and perceive it. There's also familial status, which I'll go into a little bit more in a bit, protections for disability, and for religion. There are actually additional protections as well in Orleans Parish, since that is where our office is located. Some of my talk today will be focused on Orleans Parish, but Orleans Parish has additional protections explicitly for sexual orientation, gender identity, marital status, age, and creed. And creed is a sincerely held belief. It can be a moral one, it can be ethical or religious. So when and where does the Fair Housing Act apply? So covered dwellings are a lot larger than people think. It's not just apartments, condos, and houses, but also trailer parks, group homes, dorms, homeless shelters, and nursing homes. And same for covered transactions. People generally assume that this only applies to rentals and sales, but it also applies to insurance, lending, advertising, zoning, and harassment. So the Fair Housing Act really can protect you in a wide range of dwellings and transactions. Here we go. All right. So national discrimination complaints. Most people, as I mentioned before, assume that most fair housing complaints are going to relate to race. And while it is the second most common complaint at roughly 18%, it's actually disability with over half of all national discrimination complaints relating to. Most of those disability complaints involve denial of a reasonable accommodation or disability access. And then the third most prominent one is for familial status. So familial status is and it's a case when, well, the most common one we're seeing is when places don't want children to be living there. So you might be interested in applying to an apartment and you reach out and they say, actually, we don't allow kids to live here. That's discrimination and it's protected under the Fair Housing Act. So if something like that happens to you, or say you're interested in moving to a house with a pool and they're like, we don't want kids in this apartment because we're worried about safety. That's illegal discrimination. So if you ever encounter a situation where you're not allowed to live in a place or have other restrictions due to the status that you have children living with you, that would be considered illegal discrimination. So we're going to dive a little bit more into disability discrimination since it's the most prevalent one we see. What is a disability? So someone who is disabled under the Fair Housing Act is an individual with a physical or mental impairment that substantially limits one or more of a person's major life activities. The Fair Housing Act also includes someone who's disabled as an individual regarded as having an impairment or an individual with a record of impairment. So that's like, for instance, if you had cancer and it's in remission, you still have that history, so you still have like a disability, or someone who is perceived as having a disability, whether or not they have that. Um, When it comes to disability discrimination, like I mentioned before, most of the time it's when housing providers don't want to work with the individual to make sure that they are entitled to full use and enjoyment of the property. Way that you have access to full use and enjoyment of a property is oftentimes through an accommodation or a modification request. An accommodation is an alteration of a rule, policy, practice, or service. Some examples of those would be an emotional support animal, having an assigned parking spot due to some mobility issues, or adjusting a rent payment schedule. An example of that would be if you receive disability from the government every month, and your payment comes in on the 5th, but rent is due on the 1st. A reasonable accommodation would be asking for your landlord to move that due date to the 5th, so that way your income will be coming in on that same day, and you won't be late every single month. A modification is a removal of a physical barrier or additional physical elements. Some examples of that would be widening of doorways in the unit to make sure your wheelchair can fit, removal of below counter cabinets, or installation of a wheelchair ramp. As long as these are reasonable and necessary, it's considered something that your property should have to do to comply, and to avoid disability discrimination. So let's say you have a disability and you want to make an accommodation. How do you go about doing that? So to request an accommodation, I recommend really these 3 steps. The first one is to ask for an accommodation with your housing provider. You can do this at any time. The request doesn't have to be in writing, but I always recommend that you do so in writing, because if they fail to accommodate you, it's easier to prove that discrimination has occurred. Um, Additionally, I recommend providing documentation from your healthcare provider that specifies why this accommodation is necessary. I know this is very important. It does not have to state what your disability is. Your landlord does not, or whoever your housing provider is, does not have that requirement to know exactly why you need this accommodation. All you need is a letter from your doctor explaining that due to your disability, whatever it may be, you need this accommodation. Now, if you've done these 2 things and your housing provider is unwilling to work with you, at that point, I recommend reaching out to the Louisiana Fair Housing Action Center, or the Disability Rights Louisiana, to get some support and to help your housing provider understand that this is a legal discrimination if they fail to provide this accommodation. And as I mentioned before, this is very prevalent. This is a lot of the cases we're seeing these days. So if you're having any issues, please, please, please reach out to us. Another area of discrimination we're seeing a lot within housing, especially in cities, is sexual harassment. The Fair Housing Act prevents or protects tenants and housing applicants from harassing conduct. One of the most prevalent types of this, as I said, is sexual harassment. The harasser can be a landlord, a property manager, a maintenance worker, or even a neighbor. And there are 2 different types of sexual harassment. The first is quid pro quo. This would be an unwelcome request or demand being made as a condition of housing access. So the most common one we're seeing is demanding sexual favors in exchange for allowing a tenant to pay rent late. The other type of sexual harassment we're seeing is hostile environment. And this is when the harassment is so severe and pervasive that it interferes with your ability to access and live in a housing or space. The most common form of harassment by far is quid pro quo. We're seeing that about 93% of cases. And especially when the perpetrator is offering to or attempting to obtain sex in exchange for you being able to live there, reductions in rent, or for even repairs. Um, I did want to talk about a real life example. In Baltimore, there was a case where at least 100 tenants were forced to exchange sex for repairs or forced to live in an apartment without functioning kitchens, bathrooms, or heat. The housing authority ignored these tenants' complaint, and eventually the case was settled in 2016 for $8 million, going to the victims. So this is a prevalent area of the law where there's a lot of sexual harassment going, people abusing their power, but thankfully there's also a lot of, I guess, justice going on, where if you are facing sexual harassment, there really is a chance that be you can address those harms and you can try to be made whole again as much as you can be. My general advice for people facing sexual harassment is many people who are facing this are very embarrassed and they don't want to tell anyone about what's happening. Even if you're unsure about if you would want to pursue legal action, make sure you're documenting everything, okay? Like take screenshots of conversations if your landlord or your property manager or anyone is saying anything inappropriate to you. And this is the most important thing. Make sure you're telling people in your life. We've had to unfortunately refuse some cases where people are telling us about sexual harassment, but they don't have any evidence of it. And they're like, "Did you tell anyone?" And they're like, "No, I was too embarrassed." And it's like, tell your friends, tell your family, anyone who can say, "No, this has been going on for a long time. She's been telling us," or he or whoever has been telling us about this for years. It's really, really helpful to be able to prove that you really did go through this. And a lot of harassers are smart. They're not, they know they don't want to get caught. So at the very least, tell someone. It's good for you and it's good for your legal case if you decide to pursue it. All right. So to close off our Fair Housing Act discussion, if you're facing housing discrimination, you have some options. You can either file a report with the U.S. Department of Housing and Urban Development at, oh no, my link is gone. Hopefully they'll throw it in the chat. But you can also just Google file housing complaint and this will pop right up. It's a very slow process, I'm not gonna lie. It can take months to years, but it's really useful in getting some of your rights to, enforced and protected. The other option is to work with the Louisiana Fair Housing Action Center. So you can give us a call at 504-596-2100, and tell us about what's going on. Tell us about your case. Tell us about why you think you're facing housing discrimination, and we might be able to assist you in filing that complaint with HUD. I also wanted to give a shout out if you are a landlord who wants to know more about Fair Housing Act protections, please. The Louisiana Fair Housing Action Center is doing a training next week. I highly recommend you attend. It's some really important work, and I wish more landlords took the time to understand what their responsibilities are. So yeah, these are all great resources. Please, please, please reach out to us if you think you're facing any type of housing discrimination. All right. So next on our discussion is we're going to be talking about landlord tenant issues. So unfortunately, there's a whole slew of different issues that many tenants are facing, but today we're only going to focus on two. What you can do if your landlord won't make repairs, and what you can do if your landlord won't return your security deposit. The first one is repairs. Okay, so if your landlord won't make repairs, you really only have two options. You can either do a repair and deduct, or you can terminate your lease. The first option is what I generally recommend to people, repair and deduct. If your landlord is failing to make necessary repairs within a reasonable time after you notify them, you can fix it yourself. Once again, all of this needs to be in writing. Make sure because they can try to fight you later on. So make sure everything is in writing. You can demand immediate reimbursement if you notify them in writing, wait the reasonable amount of time, and then fix it, and then notify them that you're fixing it, and then fix it. And that's a very long process, but it's worth it, I promise. You could demand immediate reimbursement once those repairs have been made, and you can apply that amount to the payment of your rent. But only if the repair was necessary and only if the amount you paid was reasonable. If you like don't have your friend do it and jack up the price so you don't have to pay as much in rent, just make sure, we're all trying to be above bar here. Make sure if you're going to repair and deduct, you're recording everything, you're notifying your landlord in writing, and you're being reasonable about it. Don't just like make like you're like, oh, I want to like a mounted TV. Like, don't do all that. This is for really necessary parts of your apartment that need improvements. The other option is to terminate your lease. If your apartment is substantially impaired, and you are allowed to terminate your lease either by agreement with your landlord or by suing your landlord in court, so that way you can break your lease without their consent. My number one piece of advice for this area of the law, whatever you do not stop paying your rent. While that is a legal option in other states, in Louisiana, any tenant who withholds their rent can be evicted for non-payment of rent. It's different from repair and deduct. That's a valid defense. But if you just stop paying because your landlord won't fix what you need them to, I've seen it too many times in eviction court. It's just not worth it. Okay. Do the repair and deduct if you really need to, but don't, whatever you do, don't just stop paying your rent. I did lie. Oh, there is a third option for those living in Orleans Parish. The Healthy Homes Program is a government program that ensures that all rental properties in New Orleans meets important housing, safety, and maintenance requirements. So if you're having a like fire hazards in your home, if your heat's not working, other major issues, please submit a complaint. You can either do so by calling 311 or you can log in at NOLA311.org. The great thing about this program is it's going to really try to hold your landlords accountable. It's not a perfect program, I will say that. It's a little slow. It can take weeks to months. But if you don't have the funds to do the repair and deduct yourself, I highly recommend it. There's a there's an investigation process, there's an administrative hearing. The judge will ask you, are you happy with these improvements that have been made? It's absolutely worth it, and it's a really great program that's only been in effect for the last few years. The another great part of this program is that you have a right to make a complaint without fear of retaliation. If you make this complaint through the Homes program and your landlord gets upset, threatens you with eviction, please call the Southeast Louisiana Legal Services. Their number is 504-259-1000. They're in the law itself. They cannot retaliate by trying to evict you just for making this complaint. At the same time, make sure you're paying your rent because it's not a defense from that, and make sure that you're complying with your lease. So if there are other issues, unfortunately, this defense doesn't work. So if you're going to make that complaint, make sure you're still being the perfect tenant you are already being, and you'll be able to stay in your home. The next area we're going to talk about is your security deposit and getting it back from your landlord. As everyone I'm sure in this talk knows, you have to pay a security deposit when you move into a house. It can be 1 month's rent, it can be less, but your landlord must return your deposit within 1 month of you moving, unless they need it to remedy damage beyond normal wear and tear or remedy a tenant default. Before I go into a little bit more about why they can keep it, I do want to point out there is a current bill that's being debated in the legislature right now that would increase that amount of time from 30 days to 45. So keep an eye on, I wrote it down, let's see where I wrote it. Louisiana House Bill 292. If it does pass, then landlords will have 45 days to get your security deposit back to you. Okay, so important bill to keep an eye on. Okay, so when can a landlord keep your security deposit? If you terminate your lease early, and you just move out, if you have an abnormal cleaning costs, non-payment of rent, any unpaid utilities, or damage to the property. If your landlord retains any portion of the deposit, they must provide a written itemized statement accounting for the money retained and describing legitimate reasons for doing so. I do want to point out that landlords do not have to give receipts. So if they're saying that it was crazy cleaning costs or they had to fix damage to the property, Louisiana does not require that landlords provide receipts to show that the cost they're charging you is truly what they paid. So that's just something to keep in mind. All right. So you moved out, oh, actually, even before, how to get your security deposit back. When you move in, I know you just moved into a new place. Why are you already worrying about your security deposit? I highly recommend that everyone inspect the property for any visible defects, any damage, or missing items. Take pictures of everything. I mean, like, take too many pictures. I want your phone to be like stacked with photos or videos. Those are also very helpful in court. But take pictures of everything. And if you notice any major issues right off the bat, take those pictures, send them to your landlord, express what those issues are, what those damages are, so that way everyone's on the same page from day one. Then, years, months, weeks later, when you do move out, you got to do it all again. Now that the property is vacant, I want you to take pictures of everything, even more pictures than last time if you want. Take videos going from room to room. This is all very useful evidence. If your landlord tries to say that there was damage to the property or it wasn't clean, you now have evidence to show a judge if you need to that that is not true, that you left this place immaculate, spotless. There's not a problem to be seen. Because a lot of times landlords will just make stuff up. And so make sure you're protecting yourself. Once you vacate, I want you to send your landlord a letter with a forwarding address and ask explicitly asking for your deposit back. If you don't receive your deposit or a response, at that point, you can file a lawsuit in small claims court. Failure to return a deposit has a penalty of twice your deposit, any court costs, and attorney's fees if you decide to get one. So this is really useful. I know we're not seeing this in court very often. So yeah, if you're not getting your security deposit back, make sure you're fighting for yourself, okay? Because It's like it's unfortunate that's the landlords just feel like they get to keep that on forever. Okay. I know a lot of people really need these deposit back, so make sure you're doing everything you can from the day you move in to make sure you're going to get that. I did want to give out a shout out to another organization. This is the New Orleans Renters' Rights Assembly. They have an emergency hotline that you can call anytime. They might not immediately answer, they generally call people back, but the number is 504-539-4504. They also have monthly meetings, and I highly recommend you go. They have free dinner beforehand, and they're generally pretty good. It's the first Thursday of every month at First Grace Church in New Orleans, and it's really amazing because they always have an attorney there to give free legal advice. They also help organize. They help get a housing fund for the city. They're a really great organization. On their website, they also have a security deposit letter template, so you can just exactly what you're going to send to your landlord when you move out. You can just use that template, and it also gives you the next steps on what to follow to make sure that you're doing everything you need to do to get your security deposit back, even if it means going to court. All right, now for the final part of our chat. So we're going to talk about eviction defense. I wanted to give a quick shout out to a different organization, Jane's Place, and Aaron K. Wilson, who made this absolutely amazing comic, Help I'm Being Evicted. I'm going to be showing photos from it for the rest of the chat. I highly recommend if you're facing an eviction or you have a notice to vacate or anything like that, read the comic in full. It's so helpful. It has a ton of useful information. And the absolutely amazing thing is it's also in Spanish for any Spanish speakers out there. So check it out. You can just Google Help I'm Being Evicted comic. It pops right up. It's on Aaron's website. Um, all right. So yeah, I also wanted to give a free shout out. We're going to talk about them again at the end. But if you're being evicted, please reach out to these organizations. If you're in Southeast Louisiana, reach out to the Southeast Louisiana Legal Services. There's our number. Or if you're in Northern or Western Louisiana, reach out to Acadian Legal Services. Okay. They're super useful. They're very great groups. I highly recommend them. I've worked very closely with SLS in particular. Please, we're going to go into it later. Always get an attorney if you can get a free attorney. All right, so the eviction process is started by the notice to vacate. I have an example here that I found, funnily enough, on Reddit. It can look pretty informal. It can be handwritten. This is so early in the process. It can really be like scribbled on a napkin. Doesn't matter. The only requirement is it must be in writing, and a text message isn't enough. So if your landlord tries to give you a notice to vacate over text, that's not going to hold up in court. It is important to note that no notice of vacate is required if it's waived in your lease. I highly recommend when you were initially signing your lease, people don't read documents as much as they should. Please do read through it. If you see anything about a waiver of notice, ask your landlord if they'll remove it. A lot of times they will. If it's a big property or a landlord with a lot of different housing, they probably won't because it's a useful thing to have. It's less requirement for them. But always ask. It can't hurt. So please, 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 if you're signing a lease soon, ask them to remove that notice, that waive of notice, because it gets people in a lot of trouble. They have no idea they sign off on it. So if your lease doesn't have that notice, there are different requirements for how long that notice to vacate needs to be. The 5-day notice is the minimum amount required to terminate a lease, and this can be for non-payment of rent or a lease violation. The only benefit of it being so short is that 5 days cannot include weekends or holidays. It also does not for none of these, or for any of these, I suppose. It can't include the day that you receive the notice. So just something to keep in mind. If you have an expired lease where you haven't renewed it, and it automatically becomes a month-to-month lease, or if you have an oral lease where nothing is in writing, then a 10-day notice to vacate is required. And then for tenants with subsidies or an assistance or like financial assistance with like Section 8 or public housing, you actually are required to get a 30-day notice to vacate. So make sure if your landlord's not doing what's required in these areas, those are all grounds for a potential dismissal and eviction court. All right, so now for a rule for possession. The notice of vacate is up, and your landlord has now filed an eviction with a rule for possession application. I included a photo of what that eviction or the rule for possession looks like in Orleans Parish. But what it really means is it just means you have a court date now. It's going to list your name, it's going to list your landlord's name, it's going to explain why they're looking for an eviction. And it's very important that you put that court date in your calendar because it's extremely rare for it to be reset. To make sure you're taking the whole day off court because it can be very slow and it starts at 10 in Orleans and you might be there till 3 or 4 and like it's a long day. So make sure you're taking the day off work and ideally get childcare if you can. Um, my number one piece of advice is even if you vacate the premises before your court date, please, 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 please show up to court. Your landlord is not required to inform the judge that you've moved out. And so there's no way for the judge to know. So even if you move out, please come to court. No matter what, just show up to court and show up on time. Okay? It's so important. So many times I've seen like people facing eviction who show up like an hour late, 10 minutes late. I've seen someone 5 minutes late. And you have an eviction on your record now, and it's not going anywhere. They won't, judges oftentimes will not do a motion for a new trial. So please, 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 please show up for court and show up on time. All right, so now a little bit about illegal evictions. So if your landlord or housing provider doesn't proceed with eviction in the proper order, where they file for an eviction in the court, wait for the hearing, get the judgment, and then proceed to wait the amount of time necessary, it's considered an illegal eviction. Some examples of this include changing of the locks, shutting off utilities, using physical force or threats, even harassing you to create an intolerable living situation. If any of those happens, they're generally illegal. Um, if this happens to you, you can likely sue your landlord. And you can sue him for damages to cover costs of temporary housing, moving expenses, and any loss of personal property. You can also sue them for emotional distress and for any attorney's fees or legal costs. So if you face an illegal eviction, I highly recommend suing your landlord because that's really the only way to hold them accountable after the fact. If you're currently facing a legal eviction, you do have a few different options. The first one would be you're gonna have an attorney. I've recommended now there's so many free services around the state to get eviction defense and like an attorney fighting on your behalf. You're gonna let your attorney know, they're gonna contact your landlord. Hopefully it's gonna nip it in the bud. But like that's like once again, get an attorney. They're free. Why there's no reason not to. If you decide not to get an attorney, you can contact the police. The police ideally should tell your landlord that what they're doing is illegal and that they can't kick you out of your apartment, change the locks, etc., until a court date has occurred and the following time after that. The final option is if the eviction has already been filed and you have that court date, whether or not you've gone, it doesn't matter. You can reach out to the judge and his staff. You can let them know what's happening and the fact that you were illegally kicked out or locked out, etc. That the judge can then hold your landlord in contempt and they can order your landlord to stop this behavior. So these are all different options. I know some people are hesitant about contacting the police. That's why I recommend you get a lawyer, especially if it's free. All right. We're getting towards the end. All right. So what happens? You've got your eviction hearing. As I said before, show up to court and show up on time. Please show up on time. Please, please, please show up on time. Show up early. I've seen too many people be forced with having an eviction on their record because they weren't there on time and they couldn't defend themselves. So if you don't have an attorney, which your attorney should be there on time, so that's also another solution. Just make sure you are on time, okay? And in addition, bring everything you need. Since once again, I said it before, continuances are extremely rare. Some of the situations where I have seen continuances by judges are if like you or a family member have been like immediately hospitalized, or if like ahead of time you notify the court that you have like a work trip. Like those are like really the only situations. It's extremely rare to get your a court date reset or to ask the judge for more time. So make sure you're bringing everything you need on that first court date because it's probably going to be your only court date. Make sure you're bringing your lease. Make sure you're bringing your notice to vacate. Bring any receipts for rent, especially if it's for non-payment. Bring any receipts for repairs you made. If you did a repair and deduct, make sure you're bringing all that documentation to show that you notified your landlord ahead of time. If you are on subsidized housing or have a voucher, make sure you're bringing documentation that shows that. If you have a lease violation case and your landlord saying you did this one thing and your neighbor saw everything and you didn't do that, especially like if you get like in a fight with your neighbor, you have a different neighbor. You have like someone who can vouch that you did not start this fight, you did not enter this fight, like it was you were forced into it. then bringing a witness in can be really helpful because it shows the judge that it's not just like your word versus your landlord. So bring witnesses, bring people who saw what happened. My other piece of advice is to make sure you dress appropriately for court. This is so important. People really will wear anything to court these days, which I get if you have like a lot on your plate, but you can always help your chances. Make sure you're not wearing any hats or head coverings unless they're religious. No shorts, no tank tops. Don't bring anything graphic, honestly. Like not like oh, like anything like words on your shirt. Like dress professionally. I know everyone's got that button-up shirt they never want to wear. Stick it on, come to court, look professional. Unfortunately, like it really will help your chances. The judges will react and see that you're taking this seriously. Is there anything else I wanted to say about this? Okay, no, next. All right, court outcomes. So we're gonna go the good, bad, and the norm. Best case scenario, the judge hears what you have to say, dismisses the case. If your case is dismissed against you, you get to stay in your home. This doesn't mean your landlord won't refile, but at least for now, you get to stay in your home. Worst case, 24-hour rule absolute. So what this means is that you must vacate within 24 hours of the judgment being tacked to your door by the constables. This is the automatic outcome if you don't show up, if you are late. And this really scary thing about this is an eviction will stay on your credit report for 7 years. It can really impact your ability to do many other things, get loans in the future. It'll impact your ability to find housing. What I've said it before, I'll say it again. Make sure you show up to court. Please, please, please show up to court. Because it's mostly, especially in Orleans Parish, we're not seeing judges give 24 hours evictions as long as you show up. They'll give you some more time. We're like, please show up to court. The other option that we're seeing most of the time are consent judgments. And so this is when you and your landlord come to an agreement. You either decide to do a payment plan if it's for non-payment to catch back up, or you just do a move out date. Failure to stick to these conditions can lead to a judgment of eviction. So make sure as long as you're sticking to them, you're going to be good. The eviction's going to be in your past. You don't have to worry about it. I do want to mention that the outcome for both the work for rule absolute and the consent judgment are the same if you don't stick to the conditions. So if you don't move out within those 24 hours or stick to the conditions of the consent judgment, your landlord can then proceed with the eviction. First, he'll have to go back to the court and get a warrant. This is not a criminal warrant. I don't want you to have to worry about that. You're not going to be arrested, but it does mean that the constables will then be allowed to come to the property and physically remove you and your belongings. So once they get the warrant, it'll be tacked to your door 24 hours after that, then the constable is allowed to come and physically remove you and your belongings. I also want to mention that while you will only have an eviction on your credit report if you have an eviction like ruled against you, however, there are many like services and background checks that include if an eviction was ever filed against you. So really do what you can to try to avoid the initial filing because that can impact your life still, even if it's dismissed. All right, so here we go. Free eviction defense services. Please, please, please keep this information in your back pocket. Acadiana Legal Services and Southeast Louisiana Legal Services are both amazing organizations. They will provide you with free legal services. Please, please, please reach out to them. Eviction defense is a very specific type of law. Not a lot of lawyers know about this. If you have access to free legal services, I highly recommend you take them. I've never seen a scenario where a lawyer makes the situation worse, even if you're prepared to like go in and make that agreement with your landlord. It doesn't hurt if you have a lawyer looking over your shoulder being like, actually, I'm noticing a bunch of grounds for dismissal because you can't get an eviction if it's dismissed. If you do a consent judgment and you can't stick to it, you can still get that eviction against you. So write these names down, write these phone numbers down. I highly recommend, please, please, please get some free legal assistance if you're facing eviction defense. This can really impact your life. It can impact your family. And I just want to make sure that you're advocating for yourself. So, all right, that's all I've got. All right, are there any questions?
There are many questions, so
Okay.
we'll just
I'm ready.
go top to bottom and get through as many as we can. Okay. Can you explain whether or not a landlord can refuse housing to a person who has an emotional support animal?
So no, that is illegal discrimination on the grounds of disability. Unfortunately, it's something we're seeing all the time. I myself have an emotional support animal and I have been denied housing, but that was before I was an attorney, so I didn't know I had protections. Yes, that's illegal. Reach out to us. Give Louisiana Fair Housing Action Center a call. Let us help you. Because yeah, we need to make sure that landlords aren't doing that anymore.
Okay, great. Thank you. All right, here we go. Can a landlord serve an eviction without cause?
Without cause. So yes. Unfortunately, especially if you're on like a month-to-month lease, they can really move forward with that eviction at any time. They can just say, I want the property back. So that's why I highly recommend if you're gonna renew your leases, do them for a long enough amount of times. Do them for a year. Month-to-month leases really allow your landlord to do whatever they want. So make sure that you are being proactive and making sure you're renewing your lease, because as long as if there isn't a lease term, then they can move forward with an eviction with no cause. If there is a lease term, you do have protections, and that's why I recommend making sure you're renewing your leases.
Great. Okay. Um, I'm gonna read this one and maybe you can understand it as someone who's more well versed in the
Mhm.
housing department. Can a landlord serve a 30-day notice to vacate, then a 5-day notice, and then accept the full month's rent?
So yes, you can give as many notice of vacates as you like, but once they accept that payment of rent, resets, you're good. You're not going anywhere until they do a new notice to vacate.
Okay.
But yeah, that's generally once you have a payment, notice to vacate reset. If they give you a new notice to vacate, you generally have to honor that. Like it resets the clock unless it's for less. So if they give the 30-day notice and then like 10 days go by, then they would have to wait the full 30 days due to detrimental reliance. So yes, but payment always resets. You're good to stay.
Okay. All right. Is there a legal statute or resource that can be given to landlords so they understand that let me see. Is there a legal statute or resource that can be given to landlords to explain the full process for eviction? Because a lot of times they're only giving clients 5 days notice, and this is for clients who are on housing subsidies.
Ooh, okay. Well, first of all, make sure you're notifying your caseworker, anyone like whoever is providing that subsidy, just so that way they know exactly what's going on because your landlord's supposed to be telling them the whole time. I'm not sure if there's like a resource that's gonna like break down eviction defense for them. I would recommend like having them talk to an attorney. But also I don't know if we're gonna be covering it too much next week, but recommend they come to our talk next week for landlords. And that'll make sure that they're following the law a little bit more.
Perfect. Thank you. All right. Is there a statute of limitations on filing to return your deposit?
Yes, I believe it's 2 years. But I always tell people 1 year because I'm not 100% sure and I should double check on that. So let's say a year just to make sure we're not like I'm not getting you in bad territory. But yeah, there is a statute of limitations.
Okay. Can a landlord evict a tenant who has paid the current month's rent but has not paid rent for the prior month?
So, all right, I guess it kind of depends, unfortunately. It depends on like when you received the filing, when you received the notice to vacate. If they're charging or they're trying to evict you for non-payment of rent, and they waived the notice of vacate, so you didn't have to do that. And they file, and then you pay, it resets. You're in good hands. You're going to be able to stay. If you paid and then they filed, unfortunately, you still owe money. So it's kind of like if you got the notice to vacate or the rule for possession and you pay, then it resets. But otherwise, no, they can still move forward with that eviction.
Okay. Are there any organizations or offices for landlords filing an eviction in New Orleans?
Sorry, can you repeat the question?
Are there any organizations or offices for landlords filing an
Ah.
eviction in New Orleans?
Fortunately, no. So there's free services for tenants. But if you are a landlord and you want some assistance, you can hire an attorney. So yeah.
Okay. If a tenant has caused damages to a unit, can the landlord take it out of their deposit?
Yes, but you would need to do the itemized receipt and in the response in the letter to explaining what you held and how much you held it for.
Um, are landlords required to repaint a unit? And if so, how often?
They are not required to paint the unit. But I guess yeah, same deal. Just take pictures of everything so that way they can't blame you for like the walls not looking great if they didn't paint them before you moved in. So just take pictures of everything.
Um, sorry, I'm just reading through
No,
this.
you're good.
Okay. Can lease terms be changed um without signing a new lease?
Yeah, I mean, if everyone agrees to a shorter lease term, then you can like take the original lease and like literally like cross it out and change it, and then everyone just needs to like sign by it and date it. But as long as
Okay.
everyone's on the same page, you can just add, you can physically edit the other lease.
What about if the change of terms is in the cost of rent?
Is in the co Oh, no, they can't do that without your consent. The only way that they can like increase the price of the rent while you're living there is if the lease term is over.
Mhm.
So if you haven't renewed your lease and so it automatically becomes a month to month lease, your landlord at any point can increase the price. But no, they can't just as long as you have that lease term, they cannot increase it.
But they can increase it once the lease term is that 1 year, whatever lease term was, is
Exactly.
it?
Yeah. So if you don't want your rent going up and you love your house, sign a 2 year lease, sign a 3 year lease, like really commit to it.
And would a tenant have any recourse if they were told that certain things would be fixed or repaired or whatever, um, and nothing has been done yet to do all those changes?
I hear this all the time, and it's really sad, but no, there's really it's like when it's he said, she said, it's just so difficult for the court to like make a ruling in someone's favor. Get everything in writing. Get everything right after that conversation. Sit down, write a little email, be like, in summary of what we just chatted about, you said you would fix this, this, and this. Can you respond to say that this was our conversation? Do something like that because it's in writing, um, it really changes everything because then they can be held more slightly more accountable. And also you can do repair and deduct. If they say they're going to fix something and they're not going to, fix it yourself after you notify them, and deduct that from your rent.
Makes sense. All right. Um, can you skip trace a tenant who is non-responsive and has not provided a forwarding address?
So can you repeat the question? Sorry, what was the first part?
Can you skip trace a tenant?
I don't know what skip trace means.
Okay.
I'm
And that's
guessing.
totally okay. If the
Okay.
answer is just you don't know, then you don't
Okay.
know.
Yeah, I'm sorry. I don't know what it means.
Totally fine. Okay. Can tenants be separated due to a change in management? And are the tenants responsible for each other's lease upon death?
Yes, if you all right. So for the death one, yes. If one party dies and the other person is still living there, then the lease is still enforceable as long as you were on said lease. If you were not on the lease, like not even listed as an occupant, then that's where things get a little more tricky. And then what was the other part of the question? I'm sorry, I forgot.
Can tenants be separated due to a change in management?
I mean, like as long as you have, okay, so if it's a change in management, it's kind of like a tricky situation. Does that mean like if someone new bought the premises, they don't have to honor the lease from the previous owners. So that I guess could technically happen, but if it's just a new management and the owners are the same, then no. Then they have to honor the initial lease.
Okay. How can you find a tenant's address if they did not leave the landlord with a forwarding address?
Okay, so if they didn't leave you a forwarding address, technically you are, oh, and they still owe rent to that question
Mhm.
too?
Yes.
Yeah, that's a tough one. There's really not too much you can do. If they don't, like, I guess you can keep a security deposit if they haven't reached out to you, and they haven't given you a forwarding address. So that's now yours, especially if they owe you money. But other than that, it's kind of difficult to bring that case against them for anything else because you don't know where to serve them. So I guess, I don't know, get a PI, like, I don't know.
Fair enough. Okay. I'm not seeing any more questions at this moment. Oh, never mind. One just came in. Oh, and another one. Okay. Can a
Okay.
tenant be can a tenant be responsible for charges associated with handicap accessibility? So if they needed to make a bathroom or kitchen accommodation.
Yeah, so it depends. That's the answer to most of these questions. It depends on like how big of a modification they're asking for, how expensive it is. If you are a huge, like a huge property with like 100+ units, you can probably afford to make those modifications yourself. If you're a small landlord and this is your only property, then I think it wouldn't be as reasonable for you to be like to have to do those costs. So it's kind of like a dance, I would say. It depends on like how much you're at capacity for and how much the court would expect you to pay. Versus, yeah, if you're a small time landlord and this is your only property, then might not be like it might not be expected for you to cover all of those costs. So it depends.
Yeah. That balancing test really comes back
Yeah.
around. Okay. Let's see. Do you have any advice for people for landlords who are having problems getting the sheriff out to watch over an eviction process?
I'm not gonna lie, I deal mostly with tenants. I have no idea. I'm so sorry.
That is perfectly fine.
Yeah, that's all I got for
That is
you.
that is okay. Um, can a landlord remove tenant's property from the rental if the sheriff comes out to supervise it after the notice to vacate has been properly done?
After notice to vacate or after the eviction has been? I would say after the eviction's been granted is a different
Mhm.
story. If the eviction has not been granted, you can't do anything. I would say you can't remove property unless an eviction has been granted. It's been 24 hours after the judgment, after the warrant. The constables are now out. I guess I would ask the constable if they would like assistance. Otherwise, you can't remove that property unless like you have like a written notification from the tenant being like, I have left. Anything in there is trash. Like unless you have like explicit confirmation that they have abandoned the property, I wouldn't touch anything personally.
Okay, so yeah, wait for the full proper eviction,
Yes,
not just the
exactly.
notice
Yeah.
to vacate.
Yeah, and talk if you're like asking if you can help the constable, like ask the constable, he'll know.
Okay. Um, oh, okay. So it seems like there may be an issue in Orleans Parish about just constables being unavailable to come out within a reasonable amount of time, I guess, to help with the eviction process. Um, I don't know if you have any thoughts on that or words of advice.
I'm generally pro tenant. That's all I'll say.
Fair enough.
It's not like a huge
Oh,
problem to me.
yeah. Okay. So I don't see any more questions coming in right now. So I'll go forward. Can you go to the next slide for me, please?
Yes. Oh, I do want to quickly say, since there are so many landlords in here, please attend our talk next week. I didn't expect so many landlords, so learn some more about fair housing rights and make sure you're not doing anything you shouldn't be. Okay? I feel like most of the time people just don't understand. So since we have landlords here, please, please, please attend our talk next week.
Absolutely. Okay, so while we wait for any last minute questions, I just want to highlight some additional resources. These may be helpful if you have a legal question that was not addressed during this presentation or you need help getting assistance. So this is the flyer for the LCBA's Find Legal Help page, where you can access a continuum of services. It includes our attorney directory, the civil legal navigator, legal aid and pro bono organizations, and the modest means directory and self-help services. While having a lawyer is always preferred, if you are unable to obtain one, another resource to mention that you can find here are the self-help resources, which include court forms. These forms are Louisiana specific and they are created and vetted by subject matter experts. Included here under the self-help services and legal forms, there is a eviction answer form available for download for free, uh, which gives you different ways to answer or respond to a notice of eviction. I'd also like to call special attention to the Louisiana Civil Legal Navigator. This is a great diagnostic tool that helps you identify your legal issues and provides customized information, referrals to legal aid, and more. It is simple to use and will give you next steps specific to your issue and or parish and location. You can also access Free Legal Answers, which is an online pro bono program that allows users to log in whenever and wherever they like and ask civil legal questions and have attorneys answer those questions through the website. It is private and acts almost like an email exchange between the user and the attorney, but please note that the user must meet certain income guidelines to use this program. Okay, so I'm going to do a last check for questions. Let's see. Okay. Okay. Doesn't seem like there are any last questions, and I know we're right at time. I'll give people like another 30 seconds maybe to get questions in. While we're waiting on that, I do want to say thank you to Alex, our lovely attorney, who's been here volunteering to share her time and expertise with us. So thank you, Alex.
Of course.
See. Oh, here we go. One last minute question. How much notice is required to the tenant? And is that business days or consecutive days?
So, okay, so back to the notice to vacate. As long as there is a lease term and this can't be obviously like for no cause evictions. 5 days notice is what is required for like non-payment or lease violations. If the lease is expired and it's now month to month, then it's 10 days. And if there's any subsidies involved, it's 30 days. And then I forgot the second part of the question. What's the
Is it business days or consecutive days?
So this is when it gets fun. So if it's under 7 days that you're giving notice, then it's just business days, no holidays. And if it's more than 7 days, then it's just consecutive days. So both.
Okay, wonderful. All right. Well, I think that just about is every question we got. Okay. So this concludes our Law Talk workshop for today. If you want to go to the next slide.
Oh, yes, sorry. There you go.
Perfect, thank you. Please save the dates for our next Law Talks, which is on grandparents' rights. It will be held May 12th at noon. And of course, here's a schedule for all the other upcoming Law Talks as well. Thank you again, Alex. This was fantastic. And I think you presented quite well on all this important and useful information. So thank you.
Happy to help.
All right, everyone. I hope you have a wonderful rest of your day.